Hello everyone. Welcome to Deloitte's Debrief Corporate Income Tax webcast series in Asia Pacific. Our webcast today is from our corporate income tax series entitled Interpretation of Most Favored Nations Clause, Impact on Non-Residents and Action Points. My name is Rakhi Modi and I'm a senior manager based in Deloitte, India. I have the pleasure of hosting today's webcast along with Diti Doshi. Diti is a manager and based in Deloitte, India. We have along with us two subject matter experts, Sunil D. Shah and Jimit Devani. Sunil Shah is a tax partner in Deloitte Haskins and Sales LLP India. Jimit is also a tax partner with Deloitte India. You may access our bios on the left side of the screen. Before I introduce the agenda for today's webcast, I would like to take a moment to highlight some of the features of our webcast console. First, all users are on listen only mode. If you have any content related questions, you can submit at any time in the Q&A box at the bottom right of the screen. We will do our best to respond to your questions during the presentation. Second, all PC users can maximize or minimize each box at your convenience during the webcast. You may also explore the icons at the bottom of the screen. If you want to download today's slides and related publications, please go to the downloads and links box. On the other hand, mobile device users can view the slides and answer the survey on screen. Thirdly, if you require an attendance record for this event, you will receive an automated email with CPE certificate after watching for 50 minutes. Now, let's give you an overview of the topics we'll discuss. We will understand the foundation of Apex Court's ruling, what the issue is, what happened over the years, and we'll unpack the reversal of lower court stance. We'll get the snapshot of the decision of the Supreme Court. Jimit will then take us to the implications and practical challenges for the foreign taxpayers. Then we'll explore the path forward for the foreign taxpayers. We'll then have some questions from the audience. Over to you, Sunil, for further deliberation.
Thank you, Rakhi, and good morning and good afternoon to all. Welcome to this webcast. Today, we will be discussing one important judgment of the Supreme Court concerning international tax, which was delivered a few months ago in the month of October. This judgment concerns the interpretation and the application of India's tax treaties with reference to other countries. More specifically, it concerns the operation of the treaty provision called the Most Favored Nation Clause, which finds place in many of India's treaties. Can we go to the next slide, please? India today has a network of nearly 100 treaties with most of the major trading and investment partners around the world. Many of these treaties have a protocol or as part of the treaty have a clause called the Most Favored Nation Clause. This clause basically says that after the signing of the treaty, if India signs another treaty with a third country of a specified group and that treaty is more favorable compared to the original treaty, then the provisions of that third country's treaty with India will be imported into the treaty with the original country. This, in a way, is a provision to provide parity or non-discrimination between different countries, those that have that particular clause in the protocol. Sorry, I think I got disconnected. Broadly, as I was saying, we have the Most Favored Nation clause in India's protocols, and the rationale for it is to grant parity with other countries. Now, the Most Favored Nation clause can cover different types of treaty provisions. It depends basically on negotiation. The most common type is where it restricts the rate of tax on certain payments made from India, typically royalties, technical services, or dividends. In some cases, it also restricts the scope of tax, particularly in case of fees for technical services. As we know, India has a source-based rule for fees for technical services, which are very broadly defined. Not only these are broadly defined, but any payment from an Indian resident for technical services under the treaties would be taxable in India, regardless of where the services are performed. Some of India's treaties have a narrower definition of fees for technical services, so that some of the services, typically those not involving transfer of technology, would fall outside that definition and then would not be taxable if they are performed outside India as business income. These are the most common provisions of India's MFN clauses in the treaties. There are some other provisions, for example, regarding deduction of expenses in computing business income, shipping and transport business, or exchange of information. As I mentioned, the MFN clause is a matter for negotiation between different countries. What we find is that the MFN clause mostly occurs in India's treaties with OECD member countries. There are very few non-OECD treaties signed by India which contain a similar clause. It is mostly in the treaties with OECD member countries. Of course, even there, it is not with all the member countries, it is with some of them. For example, as can be seen, India's treaties with Belgium, Finland, France, Hungary, Netherlands, and so on do contain these types of clauses, and most of them seek parity with other OECD countries. So a typical MFN clause in India's treaty protocol with an OECD country would provide that after the treaty is signed with the first OECD country, if India grants better benefits to another OECD country, then the better benefits advantage must be granted to the residents of the first country as well. This broadly is the feature and the typical draft in most of the most favored nation clauses in India's treaties. To show a very simple illustration, can we move to the next slide? This is just a quick example of how the most favored nation clause works. Let us suppose that the original treaty signed is between India and Spain, which was signed sometime in 1989-1990 and effective from January 1990. Now, the India-Spain treaty has a protocol which contains a most favored nation clause. Under that clause, if the scope and rate of India's taxation on technical service fees or royalty is subsequently less in another treaty signed with an OECD member country, then the same scope or rate will apply to the Spain treaty as well. Now, about 10 years after the treaty with Spain was signed, India signed a treaty with Portugal. This treaty is more beneficial for royalties and technical service fees as compared to the Spain treaty. Now, by virtue of the MFN clause in the Spain treaty, it would be possible to import the favorable provisions of the India-Portugal treaty into the India-Spain treaty. Just a couple of points to note. What is the date of applicability of the MFN clause? The clause typically itself will say that the date will be when the second treaty or the treaty with the third country enters into force and becomes effective. In other words, it is not effective from the original date when the first treaty was signed, but only from the date when the second treaty was signed. The MFN clause in India's treaties, as I mentioned, typically also covers specifically which countries' treaties can be imported, and mostly it is OECD countries. But sometimes, for example, in some treaties, it is mentioned that it can import the treaty of any other country with a similar state of development, which need not be an OECD countries, but such treaties are comparatively few. So this broadly is the background of the framework of the most favored nation clause and how it would typically operate. Now, this provision, as I mentioned, it is there in many of India's treaties, and subsequently, India has signed many treaties which would qualify to be imported under the most favored nation clause. So, SSEs, taxpayers have naturally sought to apply the beneficial treaty into the original treaty, but this path has not been without an element of controversy. So, we look at what has happened and what are the matters of litigation and controversy between the taxpayers and the income tax department. Can we move to the next slide? As I mentioned, one typical provision of the most favored nation clause would concern royalties and technical service fees. It could concern the rate of tax or the scope of the term or both. Now, under the India-France treaty specifically, we do have a provision which permits import of another treaty. And on this matter, Syria attempted to import the provisions of the US treaty into the France treaty because, as I mentioned, the France treaty originally contained a very broad definition of technical service fees, but the India-US treaty contains a narrower definition. So the company sought to import the definition of the India-US treaty, which would have resulted in exemption from tax in India. The company applied to the authority for advanced rulings for a decision in the matter. Now, the advanced ruling authority said that before the protocol can be operationalized, there must be a notification by the Indian government, and the notification must specify what parts of the protocol are to be operationalized. In this particular case, the rate of tax was mentioned in the notification, but the scope of tax was not mentioned. Consequently, the authority ruled that the benefit of the make available clause in the third country treaty cannot be imported into the France treaty, and it would remain to be taxable. Then the SSE appealed to the High Court. The High Court mentioned that in terms of the treaty itself, the protocol is a part of the treaty. It has already been notified when the treaty was notified at the time of its signature, and therefore there is nothing further to be done to operationalize the most favored nation clause. At this point, I would just like to clarify what is the meaning of the notification that is being discussed. This notification is a formal notification by the government in a document called the Official Gazette or the Gazette of India. So all government announcements, acts, bills, rules, ordinances are all made available and informed to the public through this official organ of the government. And the treaties also are notified through this official gazette. That is a notification that we are referring to. And while the authority for advanced ruling found that a notification separately for the protocol would be required at the time it is operationalized, because prior to that, the protocol remains dormant. The High Court said that no such notification is required, it is just automatic, because the original notification of the treaty contained the protocol and the most favored nation clause itself. This was one of the matters which went into litigation and then wound up before the Supreme Court. The other set of matters was regarding dividend income. Again, on dividend income, there is a most favored nation clause in many of the treaties. This basically once again refers to the rate or scope of tax. Over here, mainly the dispute was regarding the rate of tax, where reduced rates of tax in other countries' treaties was sought to be imported by the SSEs. Here, the SSEs were residents of Netherlands and Switzerland. In both India's treaties with Netherlands and Switzerland, there is a most favored nation clause concerning dividends, the rate of tax, and India subsequently signed treaties with Lithuania, Slovenia, Colombia, which provided for a reduced rate of tax, and the SSE sought to import the reduced rates of tax into the Netherlands and the Switzerland treaty. Now, apart from the matter that we have discussed regarding the requirement of a Gazette notification to operationalize the protocol and the most favored nation clause, there was one other issue which arose in these treaties. As I mentioned, most of our MFN clauses are with OECD countries, and again, the cross reference or the parity that is being sought is with other OECD countries. So typically, the clause would say that if after signing the treaty, let's say with Netherlands or Switzerland, India India has a treaty with another OECD country which gives a reduced rate of tax, then that reduced rate of tax should be imported. So far, so good. But in these cases, what had happened was that at the time India signed the treaties with these countries, Lithuania, Colombia, Slovenia, they were not members of the OECD. They became OECD member countries later on at a later point in time. The argument of the taxpayer was that once these countries with a more beneficial rate of tax on dividends become OECD member countries, maybe at a later point of time, from that point of time, the reduced rate of tax in those treaties must be imported into Netherlands and Switzerland. Of course, the protocol of these treaties was never notified by the government till now. On this, the tax department had two counterpositions. One was that unless there is a notification, you cannot get the benefit. Apart from that, the argument of the government was that while these countries' treaties do provide for a lower rate of tax on dividends, at the time we signed the treaties with those countries, they were not OECD member countries. Since at the time the treaties were signed, these were not OECD member countries, the reduced rate of tax was negotiated in that context. Therefore, even if subsequently these countries became members of the OECDs, their treaties would not qualify for importation through the MFN clause into the Netherlands or the Swiss treaties. On this point, the taxpayer had applied to the income tax department for a certificate of reduced withholding, which was turned down by the assessing officer for the reasons that I mentioned. Then the SSEs approached the High Court, and the High Court ruled in favor of the taxpayer on both the issues. On the first issue, it concurred with the ruling in the case of Styria that there is no notification required once again to operationalize the most favored nation clause in the protocol. On the other issue, on the interpretation of what is the meaning of the phrase, the third country is a member of the OECD, the court sided with the taxpayer to say that the test of membership of OECD need not be applied at the time the treaty with that country is signed. The test of membership can be applied at the time when the treaty is sought to be imported and the most favored nation clause is sought to be operationalized. Therefore, if at a later point in time the country becomes a member of the OECD and the MFN clause is sought to be operationalized at that point of time, because the condition of OECD membership is fulfilled, that treaty qualifies for being imported into the original treaty of Netherlands and Switzerland. So, as we have seen, the High Court broadly ruled in favor of the taxpayers on these issues. In response to that, the Central Board of Direct Taxes set out its position more clearly in a circular containing 4 or 5 points on what would their position be regarding interpretation of the MFN clause. Before that, I can just mention that while this dispute was in progress in India, the Netherlands and France issued internal instructions for their respective countries saying that the most favored nation clause can be applied and is operational. With this background, the Central Board of Direct Taxes issued a circular about 2 years ago in February 2022. The first point clarified in the circular was the position of the Central Board of Direct Taxes on the interpretation of the word is, and at what point of time should the test of OECD membership be applied. The Central Board of Direct Taxes said that in their opinion, the test of OECD membership of the third country whose treaty is thought to be imported has to be applied at the time of signing the treaty itself. And any accession to OECD membership later on by that country would not qualify that treaty for being accessed to the MFN clause. The reason being that at the time of signing of the treaty, the country was not a member of the OECD, and it was keeping that fact in mind that India would have granted the reduced rates of tax. Therefore, subsequent membership should not permit that treaty to be accessed. The next important point which was clarified by the CBDT in the circular was that before the protocol or the most favored nation clause can be operationalized, it must be notified through the official gazette through a gazette notification. The protocol has remained dormant till this point of time because no other similar treaty was signed. Now it is sought to be activated because the third country treaty is signed, and for that activation, India has to agree as to when it will be activated, whether it will be activated, to what extent it will be activated, and only then the most favored nation clause will be operationalized. This was the second point made in the circular. The third point made in the circular was in response to the internal clarifications of the Netherlands and the France that the most favored nation clause is operational. There, the clarification was that internally Netherlands and France may have operationalized so far as they are concerned, and of course they can give benefits to Indian residents. If Indian residents claim those benefits under the MFN clause under their treaties, but these do not represent India's views, and therefore until the Indian government concurs and issues the formal notification, the benefit of the MFN clause will not be available under India's treaties. So this is how the positions were set before the case came up before the Supreme Court, the lead case being that of Nestle. We just take a look at the Supreme Court ruling and what the issues were and what was the decision. So the court ruled on all these issues. If you can just go to the next slide. In the case of Astoria, as I mentioned, the issue was regarding the scope of fees for technical services and whether a notification is required. In the other cases, the matter was one whether notification is required for the reduced withholding tax on dividends, and also what is the time at which the OECD membership of the country concerned should be tested for importing the MFN clause. So let us see briefly what the Supreme Court said. If we can move to the next slide. Broadly, on both these issues, the court ruled in favor of the revenue. It ruled first that the notification under Section 91, this Section 91 is of the Income Tax Act, and this is the section that gives the power to the central government to enter into treaties, and also gives the power to the central government to take such action as may be necessary to operationalize the treaties. The Supreme Court held that the notification under this section is mandatory before a most favored nation clause can be made effective. Until then, no local court authority or tribunal can give effect to that part of the treaty. This was the first point that the Supreme Court held, which is very important and covers almost all the MFN clauses. The second point was on the interpretation of the term is under the treaties. As I mentioned, the MFN clauses contain a clause that typically reads in this manner: if after the signature of this convention, under any convention or agreement between India and the third state, which is a member of the OECD, that treaty will be imported. What is the meaning of the word is? And the Supreme Court said that is we have to test at the time the agreement is signed. Therefore, if the country is not an OECD member country at the time the agreement is signed, it cannot be imported even if later on the country becomes a member of the OECD. In coming to this conclusion, the court laid down certain propositions. One proposition it laid down was that tax treaties are just agreements and ultimately Parliament makes the law, therefore Parliament is supreme. And it is Parliament that delegates the power to enter into treaties. And the court went so far as to say that the Parliament can even ask the executive government to refuse to give effect to a treaty, even though it results in breach of treaty. That's the first point that the court laid down. And the second was that one has to look at the past practice of a particular country, which need not be the practice of both countries, but it should be a practice which has been implicitly or explicitly accepted by the other country. In looking at past practice, the court noticed that as regards France, Netherlands, and some other countries, India has issued notifications for the protocol as well from time to time, but those notifications have differed as regarding the scope of tax, the rate of applicability, and the rate of tax, and have not always been verbatim in accordance with the protocol. In other words, full benefits as proposed under the protocol have not been granted by India or have not been granted immediately, and such practice has been implicitly accepted by the other country. And with regard to that, the court said that when this is the practice, it must be recognized as being fully applicable and must be followed. The court also mentioned that the treaties must not be interpreted that strictly as a domestic statute is interpreted, because ultimately they are agreements. And therefore, regardless of what is expressly mentioned in the agreement, it can be modified or interpreted through subsequent practice. There was one interesting point in the Switzerland Treaty which was raised by the taxpayer. It was the way the most favored nation clause was drafted. The treaty underwent the amendment from time to time, including the MFN clause. The original MFN clause said that if India gives benefit to a third country, then India and Switzerland will enter into negotiations to give benefit to Switzerland. But the amended protocol simply said that once India gives benefit to a third country, then that benefit will apply to Switzerland straight away. So in a way, it was almost automatic. But even then, the court said that even though this change has been made, yet it is not automatic, it is subject to a notification. So this is the court ruling. What's the effect of the ruling? Let us quickly look at the next slide. So, as you mentioned, this concerned basically three agreements: Netherlands, France, and Switzerland. And on Netherlands, there were many subsequent treaties signed with beneficial rates and also with reduced scope, like for example, Germany, Sweden, Switzerland, and USA. But there was no automatic extension of the benefit by the government formally. The benefit got extended in installments from time to time through several notifications, some concerning rate, some concerning scope, some concerning dividend, and some concerning technical service fees. So the court said that this practice, and likewise a practice followed by India with reference to France, where treaties were signed, but India issued notification from time to time granting the benefits in a way piecemeal. The court said that when India has followed this practice, which has been implicitly accepted or silently accepted by the other country, then this practice must be respected. On the other hand, the court found that for India, Canada, DTA, a notification has been issued. Therefore, issue or non-issue of a notification is a relevant fact, and only when a notification is issued can the treaty protocol be operationalized. So this broadly is a summary of the ruling and the different aspects. I'll give it back to Diti to continue the discussion.
Thank you, Sunil, for your insights. It seems this judgment could have far reaching implications on the non resident taxpayers who have taken the benefit of MFN clause. I now hand over to Jimit to share his thoughts on what could be the practical challenges for the taxpayers. Over to you, Jimit.
Thank you, Raki, and thank you, Sunil, for the overview and the of the judgment. This is, of course, a historical and a landmark judgment, and has changed the manner in which we used to interpret the tax treaties so far, and that is why we have seen that there are huge repercussions on it, on both the non-residents as well as the residents who are making payments to them. And let's understand what are these practical challenges and what are the positions these non-resident companies as well as the resident companies making payments to them needs to take. So far we have understood all the theory. Let's understand how it works practically. Let's move to the next slide. So far, what used to happen, because there were so many judicial precedents, high court decisions, tribunal decisions, everything, the MFN clause, which was part of the protocol, used to be applied automatically in majority of the cases. Uh, Many of the companies used to take a benefit under this most favored nation clause, taking the benefit of the make available clause, and this basically the make available clause under the tax treaty is narrows down the definition of FTS, and only in certain situations your income is taxable in India. Then the dividend income was practically will reduced to a tax rate of 5% under certain treaties due to MFN clause. Due to MFN clause, some of the interest which was earned from an income tax refund was also treated as tax free or taxed at a 0%. And because of these situations, many of the companies used to take a position that since there is no income, they don't want to file the tax return in India. While there were two views relating to the same, one view being that if you are tax not paying tax under the tax treaty, you ought to at least file the return of income, because of the fact that you're claiming a treaty benefit and the tax authorities needs to get a right to verify the same. At the same time, the another view was that since income is not taxable, you don't want to file the tax return at all, and many of the companies used to do that. Now, what has changed post the apex cost court judgment is suddenly the MFN cannot be applied automatically unless notified. So there are certain notifications which are issued by the government. That is why you need to look at each of the treaties and see whether the notification has been issued, and if yes, to what extent. Sometimes we have seen in certain treaties like Belgium, a notification has been issued, but the original protocol has been modified to include only certain incomes. And that is why you need to be careful now when you are interpreting the treaties and the protocol going forward. So in some cases, the FTS, which was treated as not taxable because of the make available benefit, will now become taxable. Interest in on income tax refund, which was treated as not taxable, will again become taxable either at 10 or 20%. And dividend income, of course, will not be taxed at 5%. It would be either 10 or 15, 20, depending on the treaties, as the case may be. Vis-a-vis the past, now let's look and see what do the non-resident taxpayers needs to do. One, vis-a-vis the past matters, and what vis-a-vis the future. Vis-a-vis the past, the question which commonly arises is whether the order will be retrospective or prospective. So, of course, this is a Supreme Court decision, an honorable Supreme Court decision. This is the law of the land, and any open matters at any level, whether it is at the time of assessment, CIT appeal, tribunal, high court, this order will apply, and this order will come into effect. So indirectly, it will have a retrospective effect for all the open matters which are there today. So if that's the case, what happens to the matters which were closed? In certain situations, there were certain intimations issued and a 5% rate was granted for dividends. What happens in the cases where a make available benefit was given in the past for certain fees for technical services and the treaty benefit was taken? Can the tax department reopen the past matters? And maybe the answer to that is possibly yes. And we have seen certain newspaper reports also emerging out of it that tax department does intend to reopen the matters of the past. So far, we have not seen such notices, but possibly that could happen. And of course, there are certain laws in relation to reopening as to how long can they reopen the matters, whether it is 3 years, 6 years, or 10 years. Depending on the facts, they will try to reopen the matters for the past. So it won't be a surprise if they start reopening the past matters and try to tax those incomes in India based on this decision. Technically, these decisions used to be, uh, you know, uh, many of the companies used to take a position that, if you're reopening the past matters, if you have already looked at that matter in my assessment in the past, and now merely because a new decision has come, and the same the officer is changing their mind because they already applied their mind and say that, oh, it is either not fees for technical services based on the treaty. Now can they say that, oh, now because of the Supreme Court decision, I would like to change my view and say it is now taxable? And can the taxpayer say that, oh no, it's a change of opinion? Here the views are divided, but looks difficult to just take a position that it is merely a change of opinion, and maybe department might succeed in taking the position and reopening the matters in the past. So it will be little bit difficult to just take an argument that there's a change of opinion, and that is why you do not take the positions of the past, because Supreme Court decision is the law of the land. So if that's the case, maybe even for the past matters, if you have any open matters, do you think you should withdraw the claim? Possibly yes. This might also help in safeguarding the penalty implications in those cases. And that comes, to the next question. Suppose everything is there for the past and say your open assessments. Can the tax department levy interest and penalty in those scenario? Because, interest for because they made a delayed collection from you after 2 or 3 years or 4 years. And that is why an interest at 1% per month. And the second question is whether a penalty can be initiated. So, answer as far as interest is concerned, normally interest will be levied for the past matters. However, there is a circular by which you may want to make an application to the government and to the principal commissioner. There is a particular section whereby you can make an application to the principal commissioner to waive off the interest for this matters, because this matter was prejudiced and there was so many high court decisions in favor, and now Supreme Court decision is adjudicated in in against the SSC. So possibly many of the companies are trying and exploring this route to at least waive off the interest. Whether it will succeed, because there is a lot of discretion involved at the hands of principal commissioners, we'll have to see whether that discretion is granted or not. But there is an option which can be explored as far as interest is concerned. As far as penalty is concerned, because there were so many judicial precedents in favor of the taxpayer, it will be a very good position to take that penalty should ought not to be levied, because when the claim was made, there were decisions in favor of the company, and it's only the Supreme Court which has reversed. And in practically one or two cases also, we have seen that the tax officer is also very reasonable, and they would say that, okay, a penalty case is not warranted in this scenario. What happens to the provisions? Do you think a notice is issued for the past matters? Do you need to create a provision in your books of accounts? And the answer to that is clearly yes. If the matter is open, a notice is issued to you, and if you've clearly taken the benefit, especially if it is dividend or something, or say fees for technical services where you've relied on the MFN and protocol is not actually notified, then Supreme Court is the law of the land, and that means the liability is very likely to be fructified. So, in which case, you will have to create a provision for the past. Now, that happens about the past. What about the future? What should I do for the future? See, what's the crux of the matter is this liability is getting fructified because the protocols are not notified. Can a representation be made to a CBDT for the future that, okay, can we all not represent to the government and see if the notification can be issued now so that at least from prospectively the benefits can be available to those non-residents. So a lot of representation and advocacy measures will have to be done. And maybe if you approach the government and the government certainly is looking for investments into India, possibly the government may accede to the request, but that time will only tell. Maybe another option could be also whether a map can be explored or not. That also can be evaluated in those scenarios. What happens when you're filing your tax returns now? If you're filing your tax return, you cannot take a position that, oh, maybe there is some review petition filed, or maybe our advocacy measures will actually result into some benefit, and that is why, I don't want to take a position which is in accordance with the Supreme Court. You cannot take such positions because now Supreme Court is the law of the land. So you will, if you are bound to follow the principles of the Supreme Court, Honorable Supreme Court, and you will have to file your return in accordance with the principles laid down by the Honorable Supreme Court. What happens to all those companies who had not filed their tax returns at all on the basis that my income is not taxable in India because of the MFN clause and because I do not make available any technical knowledge? The income is not taxable in India. That means it is zero rate. So I don't want to file my return of income. Now that will become taxable, and certainly in those scenario, you will be required to file the tax return in India, especially if you take the treaty benefit. There is an exemption under the domestic law of India where you are allowed not to file the tax return in India if you pay the tax at 21.84% depending on the domestic law rate. But if you're claiming the treaty rate, then you will be practically forced to file your tax returns in India. And for filing tax returns, there are certain compliances to be done, like obtaining a permanent account number and other procedural matters. So in such cases, you will be required to do those. Now, what happens that sometimes, you are withholding the tax, or you are wanting to pay the tax in accordance with this Supreme Court judgment. The question arises is, will the foreign country, that is whether it is Switzerland, Netherlands, or France, as the case may be, whether they will give the credit of the taxes uh, or not? The Here, of course, this question is more relevant more from a foreign country perspective, and we need to consult the expert of those countries. But as far as India is concerned, this is certainly, if you're paying taxes in accordance with the decision, it is in accordance with the provisions of the domestic law as well as the tax treaties. So ideally, the overseas country ought to give you the credit of the taxes. Of course, this needs to be reconfirmed by the expert of those countries whether credit will be granted by those countries or not. But this should be treated as the tax in accordance with the tax treaties. If I move to the next thing, so we have seen so far the challenges or which will be faced by the non-resident companies. Now let's look at the challenges which will be faced by the Indian payers because they are supposed to make the payments to the foreign taxpayers. If you can go to the next slide, please. See, what happens is that why are we concerned with the Indian taxpayers? As per the provisions of the domestic law, any Indian taxpayer making a payment to the non-resident is supposed to withhold the tax appropriately. If they do not withhold the tax in accordance with the provisions of the law, the expense in the hands of the Indian taxpayer will be disallowed. Second, the government can recover those taxes from the Indian taxpayer. Third, the government can also collect interest on them. Fourth, the government can also levy penalty for not withholding tax on the Indian taxpayer. So with all such implications and even possibly even the prosecution could arise on the Indian taxpayer. Because of all such instances, the Indian taxpayer will have to ensure that they also follow the principles laid down by the Honorable Supreme Court whenever they are making the payments to the non-resident payers. So today, if you are making the payments, is if they are making the payments to the non-resident parties, they will be supposed to say whether they cannot give you the MFN benefit just because it is there in the treaty. If the protocol is not notified, the Indian taxpayer cannot take into account the MFN clause because it has not been notified. So if they are making a payment, whether it is dividend, whether it is fees for technical services, royalty, or anything, then if the protocol is not notified, they cannot give impact to the same. If they give effect to the same, then technically they will be in violation of the provisions of the law, and also the consequences which we just discussed will equally apply to them. So that's very, very critical. We have seen many a times that the Indian payers, while making the payments to the foreign parties, there are also deciding to gross up the taxes. And why this used to happen is that typically Indian taxpayers used to say, oh, under the India particular treaty, this does not make available technical knowledge. The tax rate is anyway 0%. So let me gross up, because even if I gross up, the tax rate is still 0. Now, possibly that 0 will become 10 or 20, in which case the grossing up amount could become very, very high. So if it's 20, it could go up to 27%. So in those situations, the Indian taxpayers will have to do either of the two things. Either they will have to gross up the amount and bear the extra cost, or they will have to start renegotiating their contracts with the non-residents and see who is going to bear these taxes. And that's going to be a very, very important, which all the Indian taxpayers will have to take care for while making the payments to the non-residents. So they actually need to relook all the positions they have taken vis-a-vis the past matters while making the payments to non-residents. It's worth having a relook for all the non-resident payments. Coming to what happens about the past, can the tax officer come and say that collect taxes from them on the basis that this is a retrospective? Maybe the answer is possibly yes, the government can collect the taxes, but technically it's a very good case that you can say that there should not be any penalty, because you cannot be penalized for a decision which has just come now, and in the past there were so many decisions in favor. So possibly there will not be any penalty on the Indian taxpayer. But going forward, certainly it is must to do for the Indian taxpayers while making payments to the non-residents to withhold the tax in accordance with the law. If there are open matters, it will be a challenge, and government can recover the taxes possibly from them. Very important thing, which the Indian taxpayer just needs to, as I said, look into it, is see if they can want to renegotiate their contracts with the non-resident to safeguard themselves. If we can move to the next slide. Just having understood the law, let's have a look at the polling question. And if you can answer those questions, that will be very good. Does this judgment impact you with the increased compliances or the taxation? And this is equally applicable both to the non-residents as well as the residents.
Now, Jimmy, while we await the audience responses, just one question. Are you seeing many issues and questions from taxpayers in general on the impact and implications of these rulings and the way forward?
Yes, Sunil, we are seeing lots and lots of questions being asked from various non-resident companies as to especially in some of the countries like Switzerland and France and everything, where the government had issued a notification already by those governments, and where the dividend was taxed only at 5%. Now the Indian government says, sorry, we disregard it. So there were a lot of questions regarding how can one government unilaterally decide on something. So there were a lot of questions, of course, raised by such non-residents, and of course they were also a little bit worried about the increased compliances which they will have to do in India going forward, and in some cases also increase in the tax cost for those cases, especially because they would not have budgeted this increase in tax cost when they would have either invested into India or had undertaken certain transactions. So, if you can go, so maybe the results have come in, and certainly, if, I'm not surprised. Uh, this that certainly if you look at the results, almost 47% of the people do believe that there has been an increase in the tax compliances, and some of them have been partly impacted by the same. So almost if you see 70% of them have been impacted or partly impacted by this decision. Um, Only very few of them have not been impacted by this decision, maybe from those countries where uh, they were not relying on the MFN clause or there was no particular dividend benefits, such as the US. So such countries may not be very impacted, but all the majority of the European countries are impacted. So if you can go to the next slide, just to summarize, these all countries, non-residents coming from all these countries, whether it is Belgium, France, Netherlands, Spain, Sweden, Swiss, and Hungary, there will be an impact of this judgment on all those cases. Earlier, which were covered under MFN, we have given in the left, which is royalty service fees. And the impact of this judgment is now FTS will become taxable. Same way, earlier there was an exemption for dividend interest, royalty, and FTS under France. And now, if you see practically, dividend interest and FTS will be taxable in India because of this amendment. So, in a nutshell, if you see, all the companies coming from all these jurisdictions, or sometimes you don't have a headquarter in this company, but many a times you have a holding company in these countries. All such countries will also get impacted when they are venturing into India. So you need to be extremely careful, relook at the positions taken in the past, and see what are the positions you would like to consider in the future. Revisit your past position to see whether you want to create a provisions, and maybe for the future see whether you would like to budget in either this tax cost or the additional tax compliances, and file your returns in India accordingly. Maybe that is a quick summary of the entire decision which we have uh, so far. So maybe I would like to now hand it over to the to Diti to take the proceedings forward.
Thanks, Jimit. Thanks, Sunil. This brings us to the end of our today's discussion, but we have some time to respond to a few questions from our audiences. So, the first question is: notification to India France protocol only restricts the rate of tax on fees for technical service and not scope. In this case, whether a separate notification would also be required for limiting the scope? Sunil, happy to have your thoughts.
Well, Diti, in fact, this is the point which has been referred to by the Supreme Court in the judgment. It says that the government, as a practice, has issued a notification at a later point of time. And while the protocol did cover both the rate of tax and the scope of tax, the government in the notification has consciously limited the relief and the operation only to the rate of tax and not the scope of the definition. Consequently, as of now, it is only the rate of tax benefit that can be claimed under the France Treaty, and on the scope of tax and the importation of the make available concept cannot be done unless there is another notification bringing that concept in, as was done in the case of Netherlands.
Thank you, Sunil. The second question is: Is this judgment being reviewed by a review petition, or does it stand to be the law of land? Requesting Jimmy to throw some light on this.
So, of course, a review petition has been filed against this judgment in the Honorable Supreme Court. Uh, but frankly, time will only tell whether it has been accepted, and even if it is accepted, whether uh, it will be overturned or not. So, till that happens, and that's a question mark, nobody knows that. Till that happens, the Honorable Supreme Court's decision, even whether you agree or not, is the law of the land, and we are bound to follow that decision. If we are taking any positions which is not in accordance with the principles laid down by the Honorable Supreme Court, that would be clearly a violation of the law, and there would be certainly interest and penal consequences for not following the law. So it is a law of the land which has to be followed till review petition is not only accepted but also the judgment is overturned. You never know what's going to happen. So you have to treat this decision as final uh, till something comes up.
Can I add one comment over here, DT? Just to expand on what Jimmy mentioned, so far as a review petition is concerned, it is not like an appeal. In an appeal, all the issues are open and arguments are read on all the issues on both sides, and the court will weigh the arguments on merits and arrive at a judgment. On the other hand, the scope of a review in a review petition by the court is very limited. It is only a glaring error or something that is very, very clear and does not admit of different arguments that can be considered. So it is not that the entire matter is open before the court. We have to keep that in mind when looking at the review petition and the possibilities.
Thank you. This was insightful, Sunil and Jamin. Let's take the third question. Will the Supreme Court decision apply only to tax treaties, which were the subject matter before the Supreme Court in this judgment, or to all treaties in general? Requesting Sunil to address this.
Well, that's an interesting question. See, India follows the common law principle. It's a common law country. And under that principle, a judgment pronounced by a court in a particular case is binding in other cases as well. For example, a judgment pronounced by the High Court of a state is binding all over that state on that issue. And likewise, the judgment of the Supreme Court, although it is rendered only for the three SSEs or some other SSEs as mentioned earlier, it will apply to all cases which are similarly situated. The principle is that the Supreme Court declares the law as it always stood, and that is the law, and therefore, under the common law principle, will apply to everybody.
Thank you, Sunil. That unfortunately is all we have time for. Thank you, Sunil, Jimit, and Raki, and special thanks to all of you who were able to join us today. We would like to encourage you to fill out the short survey that will pop up on your screen momentarily and tell us what you think about today's program. If you joined us late, please note that this presentation will be archived for future viewing. If you feel that others would benefit from this webcast, please share the webcast via the share this icon or have them visit the Debriefs website. We will respond to all the questions submitted during the webcast in a couple of weeks. Also, if you think of any other questions or comments later, please feel free to reach out either to me or our speakers, and we would be more than happy to talk to you on this. At last, from all of us at Deloitte, thank you for your participation in Deloitte's Asia Pacific Tax webcast today. Goodbye, and please don't forget to tune in to our next scheduled webcast from the Transfer Pricing series on 23rd January, which is titled Transfer Pricing Special Edition, an interview with Manuel de los Santos, head of OECD Transfer Pricing Unit. Thank you.
Thank you, everyone.